Good afternoon, friends. I'm excited about this afternoon's program for several reasons. Reason one, this is the first time the college and the Historical Society have partnered full bore to produce a single formal presentation. The two organizations have been intertwined and amiable allies for a long time. But today we are happy and proud to say that we've worked closely together to provide what you will see, hear, and learn this afternoon. We hope this is the first of other similar opportunities. This CLE, as reason number two, introduces a transition to digital presentation for both organizations. While there may be those of us who feel like we're Zoomed, WebExed, or teamed out, we do believe that digital presentation will broaden our prospective audience who can take advantage of the superb educational mission of both organizations, but without the expense of travel. Does that mean the American College is abandoning in-person meetings? Of course not. There are far too many good friends and good things that emanate from those in-person meetings. But it's hard to argue that having a digital alternative can reach fellows who otherwise would not have been able to participate. Reason number three, CLE, of course, stands for Continuing Legal Education. I have complained for years that the average CLE program all too often doesn't really provide any actual education at all. If that arouses in you the same irritation that it does in me, for the afternoon, you may now exhale and set your irritation aside. You are moments away from, first, a marvelous star-studded cast, second, a case, Plessy v. Ferguson, that is an icon of American legal history, and third, a brand new, fresh analysis of Plessy and the value and place of so-called test cases. I, for one, can't wait. The biographies of our speakers are in your materials, so I shall just capsule the Mount Everest points for each of them. Our lead speaker is the impressive Steve Luxembourg, associate editor of the Washington Post. He is a renowned journalist. He writes clearly and invitingly. He is highly sought as a speaker. And he has recently written a blockbuster about Plessy entitled Separate, the story of Plessy versus Ferguson and America's journey from slavery to segregation. If you've not already read it, you should. And we have provided a way that you can purchase one without, purchase the copy without even leaving your armchair. If you will go to the college's website, we will have instructions for how you can purchase a volume that is signed by Stephen from the Supreme Court Historical Society gift shop online. Let's turn to Steve's co-speakers. First, we will talk a little bit about former Solicitor General of the United States, Seth Waxman, and renowned Supreme Court advocate, Carter Phillips. Fittingly, both are engaged members of both the American College and the Supreme Court Historical Society. Importantly for today, both are members from what some have termed the inner circle, that small group of advocates who have extraordinary and repetitive experience before the Supreme Court. Carter and Seth fit neatly into that definition. Each has more than 80 arguments before the U.S. Supreme Court. Both know much about test cases, and they're going to share their experience with you. The fourth in this quartet is Claire Cushman. Claire is the resident historian for the Supreme Court Historical Society, and she's also the managing editor of the Journal of Supreme Court History and other publications of the Society. She knows more than anybody about the court, and she has been a moving force in putting this joint session together and recruiting our speakers, along with the college's staff. Suzanne Alsnauer, the two have worked together, Claire and Suzanne, to work out all of the myriad details that accompany as ambitious a program as we have this afternoon. I'm now going to turn the podium over to Steve Luxembourg and thank him for his interesting and informative participation in this afternoon. Thanks so much to all of our speakers.
This year's conference was supposed to be held in Washington. It's one of the country's best sites for such a meeting with lots of tourist attractions. No beaches, but like Las Vegas, plenty of venues for gambling if that's your inclination. You may have heard of them. There's the White House and the Congress and the Supreme Court. So I might as well say it plainly. We aren't living in normal times. There's nothing normal about a convention that doesn't convene. There's nothing normal about classrooms without students or courtrooms without trials or political campaigns without much campaigning. And there's nothing normal, at least for me, about talking to a camera for 25 or 30 minutes without having a clue about the audience and how it's responding. So now here's my segue to the topic of Plessy versus Ferguson and test cases. What is normal is that we're having a national conversation about race, about racial justice and racial injustice. Because race is our national conversation. We're either talking about it or we're avoiding talking about it. And right now we're talking about racial issues more than ever. I'm often asked, why did I choose to write a book about a case that is often called one of the worst rulings in Supreme Court history? The answer comes from my background. In 2012, after 40 years of writing and editing many stories that involve race in some way as part of my journalism, I felt strongly that I did not understand the racial divide in our country. The more I read, the more I found myself going back to the 19th century and the historical roots of racial separation and discrimination. Now notice that I said separation and not segregation. That's intentional. If you picked up a newspaper in the 19th century, or if you listened to a political debate about public accommodations, separation was the word you heard. Segregation is a 20th century term, and I'm trying to help us imagine the 19th century. So I'm going to stick to the 19th century word. One more point to make about the 19th century. The Supreme Court of the 1890s at the time of the Plessy ruling was a very different one than today's court. Let's try a little test virtually. When you hear or read that the Supreme Court is about to rule in a major case, what do you immediately think? Here's what I think: 5-4. Then I think, who's the swing vote? Will the conservative side hold sway this time, or will the liberals win someone over? Not in the 1890s. If we were together in one room, I would ask for a show of hands. How many 5-4 decisions did the court have during an average term in the 1890s? The answer? In some years, 0. That's right, no 5-4 rulings at all. In the 1890s, 90%, that's right, 90% of the court's rulings were unanimous. There were many reasons for this. The cases weren't as diverse, neither were the justices. There were 9 white men, all from the same class. If you were a lawyer in that era asking the justices to reverse their direction in the new legal arena of civil rights, you had a very steep hill to climb. Now, as my biography proves, I'm not a constitutional law scholar. I'm not a legal historian. I'm a storyteller, but in this case, I'm a storyteller with 70 pages of endnotes and bibliography in the book that is the basis for my talk today. So hey, that gives me some academic cred, right? When I graduated from college, I made a thorough examination of my credentials and qualifications. I realized I was in trouble. I needed a job in a field that required no qualifications. Journalism. So if this weren't pre-recorded, I might hear some knowing laughter from this audience of advanced degrees. Now, anyone with a law degree knows the Plessy ruling, but I've met quite a few lawyers who don't know anything about the circumstances that gave rise to the case. That's because the typical law school curriculum teaches the ruling, but not the fascinating story behind it. Reading a Supreme Court decision is rarely a good way to learn about the case or the people who brought it. That's just the nature of the beast. Now, I didn't know much about this case either when I started doing my research. As far as I can learn, though, the justices in Plessy had no idea that Homer Plessy's arrest was arranged. They didn't know that the railroad was a silent partner in the plan. They didn't know that the Plessy legal team had concocted a meticulous legal strategy to create the best conditions for the arguments that the lawyers wanted to make. Neither the majority's 7-1 ruling, 7-1, nor the lone dissent from Justice John Marshall Harlan of Kentucky make any mention of an arranged arrest. In fact, there's no mention of Homer Plessy's name at all in the opinions, except in the title of the case. Now, I don't think it would have made any difference if the justices had known, but I think it's one reason why the case is so misunderstood by so many people today. Homer Plessy was not a lone actor manhandled on a train. He was part of a resistance with an entire committee behind him. His role was more or less over as soon as his bail was posted. Now, before diving into Plessy and how it evolved into a test case, I'd like to lay a little more groundwork. I want to transport you back to the 19th century, to a time that is difficult for us to imagine today. We look at the world through our own eyes, and that distorts what we think we know. Tune in any TV news show today, and sooner or later you're going to hear someone say, "This country has never been more divided." Now that's an easy narrative, but not a particularly accurate one. Our divisions today are real. We should not minimize them. But never more divided? Really? Now that's a narrative we like, but it doesn't really work. Think back to 1861, to a country that saw one state after another, 11 in all, opt for secession. Now that was a country more divided. Think back to a country riven by civil war, with thousands upon thousands fighting and dying on fields that were once family farms. That was a country more divided. Remember a country in which white people chose to enslave and then separate themselves from black people. That was a country more divided. Division is baked into our country's DNA. It was there in the infamous compromise, the indefensible constitutional clause that counted those in bondage as 3/5 of a person. The South wanted its enslaved population to be counted fully, even though no one living in slavery could cast a vote. The northern states said, no, they should not be counted at all. 3/5 was the compromise. A compromise in direct conflict with another narrative, a foundational narrative, stated in the Declaration of Independence, that all men are created equal. The inspiring, powerful words of Thomas Jefferson, the Virginian, who himself was a slaveholder. How do we reconcile these competing narratives? We can't. But we can recognize the contradiction. We can accept it. What we can't do, in my view, what we should not do, is ignore it. Now, there were plenty of people of color in the 19th century who did their level best to fight the injustices of their time. They were resistors to discrimination and separation. It wasn't easy. their resistance often took place in the face of intimidation and violence. That is the message underscoring this talk. Their resistance began not in the South, as is commonly thought, but in the North, where there were free blacks. One birth of separation was Massachusetts. In August 1838, at the dawn of passenger railroad travel, the new Eastern Railroad made its first trip from Boston to Salem with separate cars for their white and black passengers. By 1840, there were 8 passenger railroads operating in Massachusetts, and only three separated as a matter of company policy. So right away, a division. The irony is there were hardly any black passengers. According to the 1840 census, less than 1% of Massachusetts' population was black, and most of them were not riding the trains. From the outset, it was clear that this company policy was for the comfort of white passengers. Some of the few black passengers resisted. Frederick Douglass was one of them. In 1841, he was in his early 20s. He had recently escaped from slavery in Maryland, and he was the newest agent of the Massachusetts Anti-Slavery Society, better known to us as the Abolitionists. Douglass was riding the trains to the society's meetings, usually in the company of a white colleague, a big improvement over horseback. On the Eastern Railroad, they would sit in the white-only car, knowing that a confrontation was inevitable. Now, Douglass was a big, broad-shouldered man, and when he resisted the conductor's order to move, he would often be finding himself with several crew members trying to eject him. He wrote in his memoirs that he once gripped his seat so tightly that it came loose from its bolts. Amazing, if true. There was another abolitionist riding the trains, a New Yorker named David Ruggles. He was not broad shoulders. He was visiting Massachusetts, and in 1841, he was ejected from a train. Now, he was slightly built, and at the age of 33, he was going blind from early cataracts. His resistance took a different form. He did something that Frederick Douglass never did. Ruggles marched into the New Bedford courthouse and swore out an assault complaint against the New Bedford and Taunton Railroad, against its conductor and its crew. Now, Ruggles lost at trial. Maybe he needed one of you to act as his lawyer. The judge in New Bedford's police court dismissed the charges, ruling that the railroad had the power to make reasonable rules about how it treated its passengers. But sometimes history is made in losing. Ruggles established a different sort of precedent. He was the first black passenger to choose the law as his weapon. Others followed, both before and after the Civil War. Those resistors stand on Ruggles' shoulders. Some won, most lost. But each generation produced new resistors who kept trying to push back against discrimination. Now, for most of the 19th century, separation was a matter of policy or custom, not law. That changed in the 1880s when several southern states adopted various laws that mandated separation by race on passenger railroads. Louisiana joined this parade in 1890, setting the stage for the Plessy case. On June 3rd of that year, Louisiana House of Representatives approved House Bill 42, known as the Separate Car Act. The House vote was not close, 56 to 23. The bill then went to the Louisiana Senate. Now, it was described benignly in the legislative proceedings as an act to promote the comfort of passenger railroads, the comfort of passengers on railway trains, requiring all railway companies carrying passengers on their trains in this state to provide equal but separate accommodation for the white and colored races. Note the words equal but separate, not as we say separate but equal. Also note the words for the comfort of passengers. But it was clear from the debate, well covered in newspapers at that time, that the proposed legislation was not for the comfort of white passengers. It was not for the comfort of passengers of color, but for the white passengers. Now, there was opposition. It was organized. It was public. People of color, mostly from New Orleans, where there was every shade across the spectrum from black to white, came to Baton Rouge to lobby against the pending legislation. They had a group. They called themselves the American Citizens Equal Rights Association. They failed. The Senate passed the bill a month later, and the group appealed to the governor. Don't do this, they said. Their leader was Louis Martinet, editor of the New Orleans Crusader, the newspaper founded by the mixed-race, largely French-speaking Creole elite of New Orleans. Martinet sent a telegram. It said simply, "Governor, thousands good and true men petition you to veto the separate car bill." The governor signed the bill. Martinet said, "We will not quit." Now, the white newspapers applauded the new law. Martinet's newspaper, the Crusader, did not. In an editorial, he made a promise. He wrote, "We will make a case, a test case, and bring it before the federal courts. No such case has ever been fairly made or presented." His choice of words were striking. A test case, as if everyone knew what that was. Louisiana law had done something unprecedented. It had criminalized the simple act of riding on a railroad train. An earlier law in Mississippi, passed in 1888, had put the burden on the railroad companies alone. A few months after the Mississippi law was passed, a Mississippi grand jury indicted the Louisville, New Orleans, and Texas Railway Company, saying that it had, quote, willfully neglected and refused to provide equal and separate accommodations. When the trial came, the railroad was found guilty and fined $250. An appeal went to the U.S. Supreme Court, and on a 7-2 vote, the justices upheld the law in the early months of 1890. The newspapers of the day paid a fair amount of attention to the ruling on the Mississippi case, yet the Mississippi case is virtually unknown today. A few months later, the Louisiana legislature followed with its version of separation. Louisiana law went one giant step farther into entirely new territory. The legislature made it a crime for the passenger to sit in the wrong car. That was extraordinary. And that was one reason why Martinet thought his group might have a chance to win in court. That's what he meant when he wrote that no such case had been fairly presented. So you're probably wondering, how do we know anything about the Plessy team's legal strategy? Because of a series of letters, several dozen between 1891 and 1896, that survive. The correspondence was between Martinet in New Orleans and Albion Turget, the lead lawyer, who orchestrated the legal strategy from his home in far western New York State. At the time, Turget was one of the most famous white advocates for civil rights in the country. He built his fame not on the law, but on the best-selling novels that he wrote about race and on his widely read newspaper column. Yet Turget, too, is barely known today. At the time, the New Orleans Committee was thrilled to have Turget on their side. How he ended up there was largely a matter of luck. A member of the committee, a fan of Turget's newspaper column, had written to Turget on a whim in 1891 asking for any advice in bringing the test case. Now, from the outset of his involvement, Turget was full of ideas about how to craft the test case. He and Martinet agreed that they did not want to bring a civil suit. They weren't interested in winning damages. They didn't want to score a victory for an individual. A civil suit might never make it to the Supreme Court. They had a specific outcome in mind. They wanted to attack the entire law, and they wanted a court to strike down the law's criminal provisions. Now, Turget was at a disadvantage. He had almost no experience in bringing cases to the Supreme Court. He was more civil rights advocate than civil rights lawyer. And he had never been to New Orleans. He had no idea of the culture and customs there. The city was unlike any other in the South. In many ways, that's still true today. But when the United States acquired the territory in 1803, there were more than 6,000 free people of color, that's what they called themselves in French, who were living there. And until the Civil War, this largely mixed race group existed as a kind of sandwich layer between the white Americans and the enslaved black population. By 1890, the sandwich layer had acquired education, wealth, and enough clout to see themselves as a force in the city's affairs. After the Louisiana legislature passed the Separate Car Act, they formed a committee that plainly stated their mission. Nearly all of them had French last names, and they called themselves, hold on to this, the Committee to Challenge the Constitutionality of the Separate Car Act. I suspect that a PR firm today would come up with a snappier name. Now, if Martinet was the committee's engineer, Turget was its architect. They traded their ideas by letter, and they arrived at a consensus. Their cause would be lost at the outset without the right sort of arrest. A breach of peace charge was useless. They were challenging the constitutionality of the act, and so they needed their passenger to be charged under Section 2, which made it a crime for any rider to insist on, quote, going into a coach or compartment to which by race he does not belong, close quote. Designing this test case required careful planning and vigilance. Over the months, their strategy evolved. They decided they could not leave the arrest to chance. They wanted to control every aspect. They needed a cooperating arresting officer. They needed to provide him with a draft of an affidavit that cited the most appropriate section of the act. And most important, number 3, they needed a railroad that would allow its crew to assist in the choreographed arrest. With Turget living 1,000 miles away, it fell to Martinet to make the arrangements. Late in 1891, he wrote to Turget with elation. Martinet had found a railroad willing to serve as a silent partner. The conductor would not make the arrest himself, he would only act as a stage manager. He would summon the arresting officer at the right moment. Turget was adamant that their volunteer passenger be light-skinned enough to pass for white. Turget was thinking ahead to his brief. He wanted to argue that if a conductor could not tell a passenger's race, then the law was unenforceable. In New Orleans, with its large mixed-race population, that was the ideal place for such an approach. As Martinet told Turget in one letter, walking up and down our principal thoroughfare, Canal Street, if you were not informed, you would be sure to pick out the white for colored and the colored for white. But the committee's first test case was a partial misfire. Their volunteer passenger was a young man named Daniel Destunes, the son of a committee member. As sometimes happens in test cases, a small overlooked detail can cause major problems. Destunes bought a ticket for the trip from New Orleans to Mobile, Alabama. He had no intention of going more than a few miles, but the ticket's final destination made his journey into an interstate trip. A few months later, when the Louisiana Supreme Court ruled in an unrelated case that the law could not be enforced on interstate trips, the Dadune case was over. A judge dismissed the charge. The committee had won, but it had lost because the test case was now done. Martinet and Turget decided they needed to start over. Martinet lined up another railroad, the East Louisiana Railroad, which operated only within the state of Louisiana, as the host for the arrest. He hired a private detective to ride the train and wait for the conductor's signal. Homer Plessy, who was also light-skinned enough to pass for white, became their new volunteer. Plessy bought a ticket for a Louisiana destination, and on June 7, 1892, he was arrested for sitting in the wrong car. Everything was working fine. A few months later, the presiding judge, John Ferguson, did the Plessy team a big favor. Instead of going straight to trial and finding Plessy guilty, as Turget and Martinet expected, Ferguson decided to issue a full-blown opinion on the constitutionality of the act. The Plessy team had argued that the case should be dismissed. Ferguson upheld the act, but held off on a trial so that the Plessy team could appeal his ruling that the act was constitutional. That dramatically changed the Plessy team's strategy. They had planned for a habeas corpus path. As they had mapped it out, Plessy would be found guilty, go to jail, refuse to pay his fine, and then they would go to federal court to appeal for his release from his imprisonment. But now, Plessy didn't need to spend a minute in jail, let alone months. His legal team could appeal Ferguson's ruling directly, and if the Louisiana Supreme Court upheld it, then the Plessy team could go to the Supreme Court, the U.S. Supreme Court, as plaintiffs, arguing that Judge Ferguson's ruling was an error. So that's how State versus Plessy became Plessy versus Ferguson. Turget had radical ideas, but like any good lawyer, he also wanted to win. And winning meant finding legal arguments that were new, that the Supreme Court, the U.S. Supreme Court, had not ruled on before. He didn't see any problem here. After all, no state law had ever made it a crime to ride in the wrong railroad car. Surely, he thought, the U.S. Supreme Court would see that as an entirely new question. Still, Turget knew that winning was unlikely. In 1893, as a new justice was joining the court, he counted the votes. He reached 5-4 only by the most generous and optimistic estimate. He told Martinet in a letter, "I think we might need to withdraw the case." But after a few months, that discussion was never held again. They persisted. Why? Both men were fighters. Retreat wasn't a word in their vocabulary. In writing his brief, Turget threw a kitchen sink of arguments at the justices. He based most of them in the 13th and 14th Amendments. The 13th abolished slavery, but it also prohibited, quote, involuntary servitude. Turget argued that sending black passengers to a separate railroad car was a form of servitude. Separation marked the black passenger as inferior, he said. As for the 14th, Turget argued that the Separate Car Act was a clear violation. The amendment said that the states could not deprive its citizens of equal protection and due process. We know those terms well today. But the Separate Car Act, he said, gave the conductor extraordinary powers to separate passengers and to determine their race without taking any testimony, without gathering any evidence. How is that fair? Louisiana law, he said, offered no definition for white or black. So how was the conductor to make such a snap judgment with no due process? The majority opinion was written by Justice Henry Billings Brown, one of 7 Northerners on the court. He rejected all of Turget's arguments. The 13th and 14th Amendments did not apply, his ruling said. He based his ruling entirely in the states' rights. Louisiana had the authority, he said, under its police powers, to separate its passengers, to keep peace and order at all times. The act, he said, applied equally to both races, equal but separate. Justice Harlan, in his dissent, embraced both the 13th and 14th Amendment arguments. The act's equality, Harlan said with scorn, was a ruse, a veneer, a thin disguise for the law's true purpose, which was to separate the people of color from the white passengers. Harlan's dissent, well known today, was notable for one other reason. He was a Southerner, one of two on the court. He had grown up in a slaveholding family. As a young man in 1859, he had run for Congress on a pro-slavery platform. But determined to keep the Union intact, if he could, he had served in the Union Army. He raised his own regiment in Kentucky, a slave state that never joined the Confederacy. After the war, serving as Kentucky's Attorney General, he opposed the three new civil rights amendments, the 13th, the 14th, and the 15th, which established voting rights for black men. He had changed his mind. By 1870, he had renounced his views on slavery. He fully embraced the three amendments. And as I wrote in my book, Separate, quote, the Southerner saw the case in a practical and historical context that none of his Northern colleagues seemed to grasp, end quote. Harlan predicted in his ruling that the majority's ruling in time would, quote, prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. Harlan's view of equality did not extend to Chinese immigrants. He too had his blind spots, his fears, his prejudices. Immigration was one of them. But unlike his peers, he managed to confront most of his past, to examine his beliefs, and he had emerged with a view that for the white and black races, equality and opportunity could not survive if they came in different colors. He not only endorsed the Plessy case and its protest, he encouraged new protests, saying that colored passengers, quote, ought never to cease objecting, end quote, to separation. Now today, the Plessy case is often described as establishing the doctrine of separate but equal. Yet those words do not appear in the majority decision. There is no announcement of a doctrine. Harlan's dissent used the term, but only as a shorthand for what the law required. So how did it become known as the, quote, separate but equal case, end quote? I'll leave that interesting question for the Q&A if anyone would like to discuss it. So to wrap up my discussion, Plessy was a notable test case for several reasons. Resistance had led to arrests before. That wasn't new. Previous resistors had taken aim at policies that required separation. That wasn't new either. But Plessy was one of the first cases, perhaps the first case, in which the legal strategy was developed long before the arrest, rather than after the confrontation. Plessy was a terrible ruling, in my opinion, but it's worth our attention as a pioneering case in civil rights law. That's a segue to our other panelists, who will be Seth Waxman and Carter Phillips, and they will take the discussion into the 21st century. Before I hand them the microphone, though, and before this discussion ends, I want to thank Claire Cushman and the Supreme Court Historical Society for inviting me to participate in today's event, and to the American College of Trial Lawyers for making this discussion possible. And thanks to all of you in the unseen audience for tuning in and for listening.
Thank you, Steve. We are now going to move from Louisiana to Michigan, from New Orleans to Detroit. And we are also fast forwarding from the 1890s to the 21st century. Our next speaker, Carter Phillips, is a modern day Albion Tourget. He will discuss his litigation strategy in a recent case, which, like Plessy, was a test case. We are privileged to hear an eyewitness account from Carter in a case that sought to establish no less than a constitutional right to literacy.
Hi, I'm Carter Phillips, and I'm here to discuss the Detroit school system litigation, which is an example of a test case in which I represented the plaintiffs in this particular case. The name of the case, as it started, was Gary B. versus Snyder, who was the governor of Michigan in 2016. The case ended as Gary B. versus Whitmer because Governor Whitmer won the election in 2018. Our effort here was to determine whether or not or to get a court to decide that there is in fact a fundamental right of access to literacy as a core element of the due process clause of the 14th Amendment. The difficulty with that argument, if you start with the sort of legal landscape at the time that we were trying to bring this litigation, is that the U.S. Supreme Court in Rodriguez, in the Rodriguez case in San Antonio, had determined that there is no such thing as a fundamental right of education. Now, that came up in the context of differentials in allocating resources among school districts. And I think the Supreme Court was reluctant to take on the role of running all of the school districts in the United States. And so even though it recognized that education is extremely important, to attach to it the idea of being a fundamental right carries all kinds of additional collateral importance. And so the court was reluctant to do that. And even that was a 5-4 decision. Subsequently, the court decided in Plyler versus Doe, again, no fundamental right of education, but there is, in fact, protection in the 14th Amendment if you arbitrarily exclude students from receiving an education. There they were actually imposing insurmountable hurdles to undocumented residents of Texas, children and their children, from getting into the public school system in Texas. And that was declared unconstitutional. What we were looking for was a situation where effectively the school systems had in fact deprived the children of the ability basically to learn and to learn how to read. And the case that we found, my co-counsel was public counsel who worked with Sidley Austin to put this case together, was that the circumstances in Detroit, Michigan were about as unfavorable to education as you will find in any public school system. And so we interviewed students and teachers, mostly former teachers. It's very difficult to get current teachers to talk about the quality of education in their system. I think they all worry about maintaining both the relationship with the school administrators and with the state in general. But what we were able to determine in those interviews is 3 elements of what we would regard as the absolute critical qualities you need in order to make education learning possible. One is adequate physical facilities. And in the 5 schools that we had identified where the students had been attending, the physical facilities were deplorable. First, they were rat and rodent infested. Second, they were obviously very old, falling apart. They didn't have adequate heating or cooling systems, so the temperatures would run between 32 degrees and 100 degrees, depending on the outside temperature. And third, there was no water available in the system. You had to bring water with you. So the physical facilities did not lend themselves to learning. The teacher situation was a very serious one. There were, first of all, you did not have to be state certified in order to teach in Detroit. That's the only city for which that's true. And second, the absenteeism of teachers in the school system meant that in any given day, there were between 1/3 and 1/2 of the teachers not available. And there were instances that we could document where ninth graders were teaching eighth graders how to read or history or whatever the class happened to be. And that oftentimes, because there was no one available, the only education that took place was watching videos. And the videos were usually not age appropriate. So ninth graders would be watching Kung Fu Panda or some other Disney movie as opposed to any kind of effort to actually learn. And then finally, for resources, the situation was in some ways even more heartrending because you would have classes with 30 students and only 5 books. And those books were all outdated. And so the idea that you could have horrible conditions, no resources, and inadequate teachers leads you to what? And that's no proficiency in reading or arithmetic. And if you look at the proficiency scores for these 5 schools, they literally were between 0 and 2%. That meant that no more than 2% of the students could read at their grade level, could do math at their grade level. And in many instances, not a single student could accomplish that. So that made Detroit a very suitable target for challenging the quality of education. There were 2 elements of the case that made it an interesting litigation choice. One is that the Michigan Supreme Court had already held that the right to education that's in the Michigan Constitution is not enforceable by private action. So there was no way to improve Detroit by litigation in state court, which is oftentimes the right way to go. And second of all, the state of Michigan had taken over the Detroit school system some 10 years before the litigation that we brought, and had done so purely for budgetary reasons, that the school system spent way too much money. And as a consequence, then did what it could to reduce the spend, which is part of the reason why the inadequate teachers, inadequate resources for teaching materials, and inadequate physical facilities were allowed to not only exist, but to get worse during that period of time, and therefore made the Michigan public officials the right people to litigate against under these in this particular case. So we compiled a 125-page complaint, which we filed in the Eastern District of Michigan, which is in Detroit, and we named the governor of Michigan, the school board in Michigan, a variety of other state administrators who were responsible for the serious deficiencies in Detroit as the defendants. And we sought to assert essentially 3 basic claims in our litigation. First, that there is a fundamental right to access to literacy embedded in the Due Process Clause, that the Supreme Court's tests of a historical basis for recognizing the importance of literacy and the idea that literacy is part of the fundamental roots of ordered liberty could be satisfied in this particular context. That the history comes from the fact that in 1867, when the 14th Amendment was adopted, the vast majority of schools, more than a supermajority of the states, had in fact a fundamental right to education in the state constitution. So education was recognized at that time as extremely important. And then second, the idea that an illiterate can exercise any of the constitutional rights is ridiculous, because if you cannot read, you cannot exercise your First Amendment rights of freedom of speech and religion. The right to vote becomes meaningless. Candidly, the Constitution itself, which is a written document, becomes beyond your ability to even access because you don't have literacy. And that was our basic point of a positive due process right, that the state has to provide you with the opportunity to obtain basic literacy. The second part of our argument was what I would call a negative due process argument. The state has compulsory attendance requirements, and they insist that the students go to schools for 7 hours a day, 5 days a week. Obviously, to do that, in order to require people to give up their liberty, there has to be a quid pro quo, and the traditional one is the ability to learn reading, writing, and arithmetic. Unfortunately, Michigan wasn't providing that. The city of Detroit wasn't providing that. And so what you're doing is merely warehousing children. You can say the warehouse has the name of a school on the outside of it, but if all you're doing is keeping them in a building that's substandard and giving them no opportunity to learn to read and write, then you're not actually providing anything as part of the quid pro quo, and all you're doing is depriving them of a liberty interest. So that was our second theory. And our third theory was that because 99% plus of the students in the 5 schools that we identified were students of color, that it was hard to imagine that there wasn't racial animus underlying the actions of the state in terms of the resources that were being devoted to the provision of education in Detroit. That's a bit of a stretch because we didn't have any direct evidence of racial animus, but our hope, frankly, was that we could get past a motion to dismiss and then see what kinds of discovery was available to find out exactly what did motivate the state of Michigan administrators in deciding how to allocate resources to these particular schools. Not surprisingly, the state of Michigan and the defendants filed a motion to dismiss. The first part of their motion was largely procedural. We had named the wrong defendants. We didn't have standing to bring the action. That one startled me to some extent because the idea that students have been deprived the ability to learn, don't have standing to challenge the resources devoted to education seems a pretty easy one, and the court didn't spend much time worrying about that. On the flip side, since the motion to dismiss was filed under the Republican administration at that time, their position on the merits was, I thought, pretty striking. The state blamed the parents and the children for the inability to read, the theory being that the children didn't care and the students didn't, and the parents didn't care. And didn't have anything to do with the quality of the education, that it was adequate, whatever that means. That changed actually after the election in 2018 when the Democrats came in. They refused to defend that part of the position taken by the defendants in the in the earlier litigation, and that was when the case got to the Sixth Circuit. In any event, the district judge had a motion to dismiss in front of him, and he helped us in some respects, and then drove a knife through our hearts in the other. Helped us by ruling in favor of the plaintiffs on all the procedural issues. Took them off the table. Said we had named the right defendants. We are in fact the right plaintiffs. This case is fully justiciable. Unfortunately, when the time came to pull the trigger on whether there's a fundamental right of access to education and literacy, the judge simply couldn't find one in the Constitution. He didn't believe that the Supreme Court cases were clear enough to allow him to allow the litigation to go forward, and therefore he dismissed. He also dismissed our other 2 theories, one on the basis that he thought we had not adequately alleged the negative due process component of the case. That's a position I think is wrong, but it's not worth spending much time on. And then on equal protection, again, he said we couldn't prove racial animus, or we couldn't allege it directly at this point. And candidly, on that score, he was correct. We appealed the case to the Sixth Circuit and raised all 3 of the arguments, even though, again, we were concerned about the equal protection. But nevertheless, it seemed to us that, at least in terms of the optics of the litigation, having the claim that these are schools that are 99% students of color has to affect at least the emotional impact of the actions that have been taken by the state of Michigan in failing to provide much in the way of education to these particular students. The case was argued in front of a 3-judge panel. The judges were Judges Clay, Stranch, and Murphy. To me, one of the most exciting parts of the oral argument was the fact that about 200 of the Detroit students and their parents arranged to be transported by bus from Detroit to Cincinnati, where the oral argument was conducted. They left at 3 a.m. from Detroit in 2 or 3 buses, got to the courthouse by 9 a.m. In time to sit in and watch the oral argument. And what is one of the most amazing experiences of my life was walking out of the courthouse after the oral argument to this huge throng of people on the courthouse steps, on the sidewalk, actually, and even into the streets, asking me what happened in that oral argument, and being able to say to them that the court had listened to us and that the argument had gone as well as I could have hoped for. And to see the tears and smiles simultaneously in the eyes of those children and their parents, at least to me, put the lie to the argument that Michigan had made earlier in the litigation, that these people did not care about whether or not their children were adequately educated, and that they really did want the school system to be improved. The Sixth Circuit, in a 2-1 decision, ruled in favor of the plaintiffs, said that there is, in fact, a fundamental right of access to literacy. I will quote you from, to me, the most satisfying portion of the opinion. It may never be that each child born in this country has the same opportunity for success in life without regard to the circumstances of her birth. But even so, the Constitution cannot permit those circumstances to foreclose all opportunity and deny a child literacy without regard to her potential. We hold, therefore, that the right to a basic minimum education, one that can plausibly impart literacy, is implicit in the concept of ordered liberty. And that was the ruling of the court. And then it sent it back to the district court, actually with leave to amend to deal with both the equal protection and the negative due process elements of the case. And so we were pretty excited at that point. The clients were obviously quite happy. That decision came down post-pandemic, so we were not able to have any kind of a real celebration. Soon after the opinion came out, the Sixth Circuit, in a surprise move, sua sponte, granted rehearing en banc. If you just look at political party affiliation in the sense of which president has selected which judges, 13 of the 18 judges on the Sixth Circuit are actually nominated by the Republican presidents, 5 by Democrats. And so the numbers on that score were decidedly, at least, not favorable to our side. But fortunately, during the period of time while after the panel's decision and before the court acted en banc, we were able to sit down with the governor of Michigan and settle the litigation. What we were able to accomplish was to get some immediate resources available to the named plaintiffs to improve the quality of their education, to remediate the inadequacies of the school system and the teaching that they had been given up to that point. We were also able to get additional resources to the school system in Detroit, which has been actually returned. Control of that school system has been returned to the Detroit citizens, so it's no longer in the hands of Michigan. That was done separate from the litigation, but does give a significant opportunity to take those resources, improve the quality of education in terms of the quality of the teachers, the resources available, and the quality of the physical facilities in which the students learn. And so, and a commitment from the state going forward to provide additional financial resources to provide the kind of education that does give these students an opportunity to learn the basics so that they can exercise all of their other constitutional rights. Obviously, when we brought this case as a test case, our hope ultimately was to bring it to the U.S. Supreme Court, but we decided that discretion was the better part of valor in terms of finding a solution that would provide some benefits to our plaintiffs in the short run, and to then look in the future for other test cases in which to continue to reaffirm the principles that were embodied in the decision or in the opinion of the majority coming out of the Sixth Circuit. As I said to the press afterwards, it's not every day you have an opportunity to assist in a court accepting and recognizing a fundamental right in the Constitution. And access to literacy, I believe, is one of those fundamental rights. And I'm hopeful that we will continue to be able to litigate in favor of that going forward. So that's a test case of recent vintage to go along with the other test cases that are being discussed by my colleagues on the panel. And I appreciate the opportunity to present this and look forward to talking with you about this litigation and the other cases as well. Thank you for this opportunity.
Thank you, Carter. Our third speaker is former Solicitor General Seth Waxman. So in keeping with our theme of litigating test cases, he will share with us his historical expertise on the role of the Solicitor General in carefully positioning cases before the Supreme Court to advance the progress of law. Seth?
Thank you. So now I have in the uncomfortable position, since I didn't tape my my talk, but thought I should do it consistent with the sensibilities of the fellows of the American College of Trial Lawyers and the Supreme Court Bar. I should do it in person. I now have the odd experience of talking into a screen that has only me on it. I do want to very much thank the two institutions that have put this wonderful program together for including me. And I want to put a personal plug in for Steve's book. There are many, many good books that are coming out all the time, but this is a page turner, and a page turner about a really, really important set of issues. So rather than, as Claire indicated, rather than talk about test cases that I've been involved either in putting together or defending against, I thought I might talk about the role of the Solicitor General, the role of the Department of Justice and the Solicitor General in test case litigation. And the Solicitor General, in fact, plays several roles with respect to so-called test litigation. First, I would call it superintendents, which is the Solicitor General who is responsible not only specifically for attending to the interests of the United States in the Supreme Court, but also for the broad superintendence of litigation in all courts on behalf of the United States. The SG is essentially the indispensable test case litigant. You know, at any point in time in the federal courts, the United States is a party in between a third and a half of all of the cases. I used to say when I was SG that at any point in time, the United States was a litigant in over 100,000 cases. And so the notion of, with that large a docket, there is an ability to try and move the law or preserve the law, both by pursuing a well thought out strategy in the lower courts, as Carter was just explaining, and also in the Supreme Court. And test case in those two courts really means two different things. In the trial court, it means finding a really great plaintiff in really great circumstances in a really great court, involving an issue that won't move the law more than incrementally, and trying to position that to be the one that goes up. In the Supreme Court, it's really a question of trying to identify cases that present themselves, and there are something like 10,000 petitions for certiorari every year, identify cases in which the Supreme Court, which present issues of importance, or that the Solicitor General considers of importance to the interests of the United States, and in the context in which the issue is cleanly presented and in circumstances that may favor prevailing in the Supreme Court. In this regard, the SG plays a role that no other private litigant can ever play, because the Solicitor, the United States wins most of its cases, but it loses lots and lots of cases, and the Solicitor General is required to authorize any appeal to a higher federal court, and most often the SG doesn't authorize an appeal on the theory that these issues will come up again and again, and this case isn't well positioned to incrementally move or preserve the law in the direction that we would like. That's not a conversation, as I found when I left the office of SG and returned to private practice, that one can comfortably have with a private client, which is, it's really too bad that we lost and we were really right, and I know you have strong interests here, but I really don't think that pursuing this is consistent with the long-term incremental development of the law. That's not a conversation that you can have. The second role that the SG plays is, of course, defending against test cases that are brought by others against the United States or against agencies of the United States. And if there's time at the end of my talk, I'll talk a little bit about this. And third, most importantly, the Supreme Court relies on the Solicitor General to a great degree to advise it about which cases of the many that are presented are best suited to test an important legal principle. The Solicitor General is the only person who can file amicus briefs as of right in the Supreme Court, including amicus briefs in totally private cases at the petition stage. In modern times, this has been institutionalized through a practice known as CVSG, in which the Supreme Court, in considering whether or not to grant cert in a private case, will invite the Solicitor General to express the views of the United States. And the SG, in responding to that invitation, will not only evaluate the merits of the legal issue being presented, but importantly, advise the court about whether this is an appropriate case to take up those issues. So I want to spend the remainder of my time talking about 4 different periods in the history of the Solicitor General's office and the role that those Solicitors General played in so-called test case litigation. And I want to start with the first 2 Solicitors General, Benjamin Bristow of Kentucky, a former law partner of John Marshall Harlan, and Samuel Field Phillips of North Carolina, who served as the second Solicitor General for 12 years under 6 Attorneys General, and along with Albion Tourget, argued Plessy versus Ferguson after his retirement from federal practice in the Supreme Court. So the SG's office was created in the wake of the Civil War because in large part, the Attorney General, who didn't have a Justice Department at the time, was overwhelmed in his ability to even handle litigation in the Supreme Court, much less superintend anything else. And the Judiciary Act of 1870 created the Justice Department and created the Office of the Solicitor General. The Attorney General's request and the President's request of the Congress was to have somebody whose principal responsibility would be to attend to the interests of the United States in the Supreme Court and write legal opinions in response to questions that the President and other cabinet officers had about federal law. But the Congress, the committee in particular that considered this legislation, had something very much else in mind. And the committee report accompanying the bill said, we propose to have a man, because it was a man at the time, who is skilled in the law, who can travel to any court in the United States from New Orleans to Boston and there present the case of the United States as it should be presented. And the President at the time and the Congress at the time, the Reconstruction Congress, had one area particularly in mind, and that was civil rights litigation in the Reconstruction South. And the first 2 Solicitors General were chosen because, as former U.S. attorneys, in Kentucky, in Bristow's case, and Philip in North Carolina, in Phillips' case, they had been successfully prosecuting criminal civil rights litigation under the then new Ku Klux Klan Act, Enforcement Act, and Civil Rights Act of 1865. And they pursued that agenda during their tenures. They were exceptionally successful in the trial courts. They were exceptionally unsuccessful in the Supreme Court. By the time cases like United States versus Reese, Cruikshank, Harris, and the civil rights cases made it to the Supreme Court, the Reconstruction zeal had cooled, and a very, very conservative Supreme Court was not inclined to give expansive readings or even to affirm the constitutionality of much of this civil rights litigation. To be fair, the SGs didn't have much control over the Supreme Court's decision to take the case or not, because the United States was the prevailing party in the lower courts. The second period I want to just touch on is the New Deal. At the time of the New Deal, I mean, Franklin Roosevelt was ushered into office in the wake of terribly desperate economic circumstances. His campaign promise was to enact and enforce legislation that would reinvigorate the economy. He had a compliant Congress who enacted legislation such as the National Industrial Recovery Act, which had been modeled after successful recovery litigation following World War I. The early experience of the United States in defending this legislation in the Supreme Court was notably, and it's well known, unsuccessful. The first Solicitor General that Roosevelt had, a fellow named Biggs, was completely incompetent. A justice on the Supreme Court remarked and told the president, wrote to the president, that Biggs was incompetent to represent the United States in any case other than a case involving a sick cow in which the cow was going to die anyway. And Biggs was reasonably quickly removed by and replaced by Stanley Reed, who then went on to serve in the Supreme Court. The initial run of cases, which largely involved the National Industrial Recovery Act, were utterly bungled in the trial courts and in the Supreme Court by the government. The government tried to defend that law in its most extreme applications, and it failed in cases like Panama Refining, United States versus Belcher, Schechter Poultry. The constitutionality of these laws were struck down, and the Supreme Court invented and applied the so-called Non-Delegation Doctrine, which, when I was defending against Non-Delegation Doctrine challenges in the Supreme Court during my tenure, I told the Supreme Court the Non-Delegation Doctrine had only one good year in US history, and it was 1937. After that experience, Reed decided to completely rechange his approach. He brought in a new team of young lawyers, and the names of these lawyers I think will be familiar to most people in the audience: Paul Freund, Henry Hart, Robert Stern, Charles Wazanski, Harold Leventhal. And they put together a strategy that involved a skillful presentation of a series of test cases to hold the remaining New Deal legislation, first and foremost, the Wagner National Labor Relations Act, constitutional, and more broadly, to get the Supreme Court to relax and ultimately eliminate its highly restrictive Commerce Clause jurisdiction. And they did it by engineering and presenting to the Supreme Court cases in a very careful succession. The first in line were cases that actually involved instrumentalities of commerce, like railroads, trucking lines, and shipping lines. Next, they brought cases involving industries that worked on but didn't substantially alter products that moved in interstate commerce, so stockyards, grain elevators, and things like that. Then they brought cases involving industries that affected interstate commerce, that is, businesses that produced goods for interstate shipment and sale or received those goods in interstate commerce. And finally, they brought a series of cases involving potential labor strikes. And this strategy was remarkably successful. The first case decided was a case called the Virginian Railway, and then a number of cases that some of us learned about in law school and may have forgotten: Fruhoff Trailer, Jones and Laughlin Steel Company, Friedman Harry Marx, ultimately leading up to the Supreme Court's decision in Wickard versus Filburn, in which the court finally overturned its previous Commerce Clause test that held that indirect effects on commerce were not covered by the Commerce Clause. And that is the view of the Commerce Clause that thankfully prevails to this day. Third out of the four, I'd like to talk just briefly about the tenure of Philip Perlman, who was Harry Truman's Solicitor General. After World War II, Truman was very forward-leaning in wanting to eradicate discrimination against African Americans. The president and the country were enormously grateful for the contributions that Black soldiers made during the war effort, and Perlman reflected that sensibility. He pursued his mission in a way that was both radical and incremental. It was radical in cases like Shelley versus Kramer, which, as you'll recall, involved the constitutionality of restrictive private covenants. In that case, decided in 1948, the Solicitor General filed an amicus brief basically saying flat out that restrictive covenants were unconstitutional, and in any event, inconsistent with the relevant civil rights acts, which were constitutional. In Henderson versus United States, which involved a passenger on a railroad, the United States confessed error, holding both that the treatment that the African-American passenger received was invalid under the Interstate Commerce Act and also invalid under the Equal Protection Clause. And in that case, decided in 1950, the Solicitor General told the Supreme Court that it needed to overrule Plessy versus Ferguson. I think it's important to pause for a minute and just underscore how unusual it is for or at least was, for a Solicitor General to ask the Supreme Court to overrule one of its precedents. But, Perlman and his staff did not mince words. At the same time, Perlman was highly cognizant of the historically successful test case strategy of Thurgood Marshall and Jack Greenberg and Spotswood Robinson at the NAACP Legal Defense Fund. And it's beyond the boundaries of this talk today to talk about what a marvelous job those men and women did in moving forward the cause of civil rights and anti-discrimination by bringing incremental cases, just as Stanley Reed did during the New Deal. But Perlman, as Solicitor General, played an important supporting role in that litigation. The United States filed amicus briefs in support of the Inc. Fund's cases in cases like Sweat versus Painter and McLaurin versus Oklahoma. And in Brown versus Board of Education, when the Supreme Court was confronting the reality that Plessy had to be overruled and that segregated schools did violate the Equal Protection Clause, but they feared at the time the consequences of simply immediately ordering that all schools be desegregated. It was Perlman and his successor, Simon Soboleff, who suggested to the court the formulation of all deliberate speed, which has been vigorously challenged, chastised, and celebrated over the years. But nonetheless, it was the role of the Solicitor General to try to give the Supreme Court a way to achieve the substantive result that the court wanted to be able to achieve with unanimity, and that the Solicitor General strongly supported. Last, I'll just say a few words about Archibald Cox, who was the Solicitor General in the Kennedy administration. And I want to focus on him just because it was an example of somebody who strongly believed in incrementalism and moving the law, and in particular civil rights law, incrementally against the very strong instincts and sometimes expressed wishes of his Attorney General, Bobby Kennedy, and the President, JFK, who wanted the United States to be out there making the kind of broad pronouncements that Philip Perlman was making. But Cox thought that that was unduly provocative, and that both the United States Justice Department and the United States Supreme Court had strong institutional interests in incremental advances in the law. And so, for example, in Bowie versus City of Columbia, which was one of the lunch counter sit-in cases, while the parties litigated the case under the Equal Protection Clause, Cox argued the case, presented the case as one in which could be decided on statutory grounds, because he argued that the South Carolina law in question was not properly read to proscribe this conduct, or at a minimum, that there wasn't fair notice to the people sitting at the counter that it did. And it was on that basis that the plaintiffs prevailed. And then in cases like Katzenbach versus McClung and Heart of Atlanta Motel, which were, as probably people remember, were cases involving the constitutionality of federal legislation prohibiting discrimination by private parties in public accommodations. Again, the obvious constitutional hook here was the 14th Amendment, which is, of course, at the heart of what this anti-discrimination law was really about. But Cox felt strongly, and perhaps rightly, that a more stable and less controversial basis to sustain the constitutionality of these laws was under the Commerce Clause. I can see, looking at myself, that I'm far over my time, and I had planned to say a few words about what it's like for the Solicitor General to be on the receiving end of test case litigation, but I'm sure everybody, including me, is interested in getting to the back and forth in Q&A, and if anybody's interested in that, I'm happy to talk about it. So thanks again for including me and putting up with me.
Thank you so much, Seth. Yes, we're going to move on to the Q&A, and there is a lot to discuss, so please, everybody, stay with us. As Seth noted, I'm going to ask Steve the first question. Steve, your book is marvelous. It's such a compelling read about the twists and turns of the litigation strategy behind Plessy. My question is, it really seems counterintuitive that they would have picked a plaintiff, Homer Plessy, who was light-skinned for a race-based challenge. And in your book, you said they even had to hire a private detective to go on board the train to make sure he was arrested. Can you tell us a little bit more about why Homer Plessy was chosen as the plaintiff?
Well, as I said in my talk, he wasn't the first of the test cases, and both of them were light-skinned members of this Creole community. I think that it's important to underline just how much Turget was crafting his arguments to make sure that he presented the court with something that it couldn't dismiss out of hand. As Seth said, the court had already narrowed its view of the 14th Amendment so much that it was easy to say, well, we've been down this road. We ruled in the civil rights cases. We ruled in the Mississippi Separate Car Act case. So Turget wanted to present them with a new argument, and the new argument was about the passenger, because the passenger had been criminalized, as I said in my talk. And I think that he thought he could sow confusion. And he made a very emotional and strong argument in his oral argument. You were on a train. And he was trying to put the justices in Homer Plessy's shoes. And he made a very difficult argument. Laugh at this argument, but he basically said, your race is your property. Now remember, I said these were justices who had a strong interest in property rights. Your race is your property, and no one should be able to deprive you of the right to pass for white if you can, because in 1890s America, wouldn't you like to be white? So you're depriving Homer Plessy of a thing of value, and that shouldn't be done without due process and evidence. The court paid no attention, the majority paid no attention to this argument whatsoever, but it's a very interesting argument. Not a very, the optics of this argument aren't very good. Think about it. If you can pass for white, you're okay, but what about that black passenger who can't pass for white? He or she's supposed to still be in the separate car. So I don't know where Turget thought the end of this argument was, but as I said in my talk, he threw a kitchen sink at the justices. I did a talk a little while ago with the chief judge of the Maryland Court of Appeals, And he thought that Turget's approach of the kitchen sink was a terrible approach. You needed to concentrate on a couple of arguments, and he would have advised Turget to stay away from these wilder arguments that he advanced.
So let me ask Carter a question. Congratulations first on winning your case in Michigan on behalf of the Detroit school children.
Thanks.
When you're litigating a test case, is your strategy different in any way because you're looking for more than just a win for your clients and you're trying to establish a larger principle?
I think the answer to that is probably yes and no, in a sense of and I should begin, I suppose, because my colleagues on the panel have already thanked our sponsors and hosts for this, and I didn't do that in my remarks. So thank you for having me here. It's a real pleasure, and anytime I can be on a panel with these folks, it's a great day. So thank you for that. The answer is yes and no. The truth is, if you're doing a test case, at least the way we approached it, you spend a lot of time thinking about the legal arguments, and you view it from a broader prism of, what do we need in order to make a compelling case? And then at some point you have to actually find real plaintiffs who fit what you've decided is the best way to go. And at that point, once you find them, and if they are in fact willing to step forward, then they become your clients. And at that stage, their interests cannot be ignored. They are your client. That's your primary responsibility, is to represent those clients. And so then you have to deal with the litigation as it moves. The interesting transition from the sort of background work that you do up to the point where you go and find your clients is, at least in a case where the issue is access to literacy, where you literally have to find, in our case, high school students who are prepared to admit that they've gone through 9, 10, 11 years of education and cannot read. It's not an easy task to begin with, but you have to find somebody who's got powerful basis for going into court in the first instance. And we were fortunate in that regard, in both that we found students willing to step forward and their parents who were willing to step forward. And I suppose that probably did as much to upset me when the state of Michigan Attorney General at the time decided to foist the entire problem on the students and their parents, rather than take any of the responsibility for the state and its allocation of resources.
So a follow-up question for you, Carter, about the Michigan case. You mentioned that you'd expected it to go to the Supreme Court and you hope to get a ruling from the justices on this constitutional right to literacy, but then you decided not to pursue it further when the Michigan legislature agreed to improve the quality of education for these students. How is that choice made? And can you talk a little in general about when you're pursuing a litigation strategy, how do you decide when to stop? And does it differ if it's a test case versus an ordinary case?
Well, ultimately, as I said, you're responsible to your client, and what are the client's interests to be served by the particular litigation. Now, we were a putative class, but the case was dismissed before the class was certified. So we literally only represented a handful of individual plaintiffs. After we got the ruling from the Sixth Circuit that it recognized the fundamental right, when the Court of Appeals in the interim then grants, without even a request from a party, rehearing en banc so that the entire court's going to hear it, it's kind of hard to not read the handwriting on the wall and recognize that this is going to be tough. Now, we could have played that through, probably have lost in the Sixth Circuit en banc, and then sought Supreme Court review on the issue. But the reality of that process is that you're asking the court to say, out of the 8,000 or so petitions for certiorari, that this ought to be one of the 70 or so that the court's going to grant. And that's an uphill climb. And the flip side of it is the state of Michigan had shown up at that point and said, look, we're willing to invest resources in the individual plaintiffs here, and we're willing to ensure that more funds are available from the state to the school district in Detroit. And so it was actually pretty easy conversations with individual clients that they were okay to take that deal and then and forego the broader proposition, recognizing we have a wonderful opinion that's out there, and we'll continue to work with it in future litigation.
Well, I think we can make a segue back to Plessy. Albion Tourget, I'm asking Steve this question, seems to have known that the Supreme Court victory was an uphill fight, that getting a victory would be an uphill fight. So for Tourget and his litigation team, was the test case a mistake? I mean, should Plessy not have been appealed to the Supreme Court?
Well, it's a little different than the cases today. It's not that they were appealing it. That was their goal from the beginning, to go to the Supreme Court. They didn't want to win it in the state court, and they knew that they couldn't. Remember the circumstances here. It's the South. It's 1890. Louisiana is the third of a series of states that are passing these separate car acts, which are codifying discrimination. And if it isn't going to happen in New Orleans, it's going to happen in Georgia, or it's going to happen in Virginia, or one of the other southern states. So they wanted to bring this case in a state where they thought they had a shot at winning. They couldn't win in the state. I mean, often in our controversial topics, you'll see advocates either go to the state legislature or go to the Congress, depending on whether they think there's a favorable environment there. In this case, neither the state legislature, which had passed the act, nor the state Supreme Court, which had upheld the act, were favorable to them, and they knew that. So should they have brought the case at all? Remember that we see Plessy as being the worst case and being notable, but at the time, it wasn't regarded that way. It was the third or fourth in these civil rights cases, and they knew they were fighting an uphill battle, but they were fighters, as I said, and they were not going to back down. And I think the idea that you don't go to the Supreme Court unless you're going to win, or you think you have a good chance of winning, is a 20th century idea more than it was a 19th century idea. And so they shrugged their shoulders and said, let's go for it.
So my next question is for Seth. You mentioned, I think, was it Solicitor General Biggs who sort of bungled it in the early New Deal era? Can you talk from your own experience of having served as SG? What are some of the risks that the OSG might face if it presents the wrong case at the wrong time? For example, a case that tests the most extreme application of the principle sought.
Yeah, so I think the New Deal, the sort of two different stories of the New Deal is the best illustration of that. In the beginning of the New Deal, the government did not have a strong Solicitor General, and decisions about which cases to bring and how to litigate them were largely being made by New Deal administrators that had been brought into, who were not lawyers, or not very good lawyers, who've been brought in to run the National Recovery Administration and things like that. And what they thought were fine cases were terrible on the law. I mean, one of them, which involved the constitutionality of the lumber codes, was brought, and it turns out that by the time the case got briefed in the United States, it was discovered that not a single person on the planet could find the lumber code. Nobody had actually read the lumber code. And so Stanley Reed had to confess error in the case. So it was just, I mean, if you bring a case to try and to test the most extreme context for the legal proposition that you're arguing, or the most extreme legal position, you're facing lots and lots of antagonistic forces. The court as an institution, by and large, wants and needs to move incrementally, because stability in the law is an independent good. And bringing a case that requires an evulsive change is not something the court is likely to do. And of course, although in the Supreme Court, the court is quite properly concerned mostly with legal principles and constitutional principles, facts matter. They matter desperately. And without a good factual record, the case is not going to succeed. One example that occurred, that I participated in shortly after I left office was the constitutional defense of the so-called McCain-Feingold law, the Campaign Finance Reform Act, which was challenged both by Mitch McConnell and the National Rifle Association on the very day that it was signed by the president. And on behalf of a number of senators and congressmen, I tried the case, handled the case in defense of the law together with the United States. And we had a battle royal in front of the three-judge court over whether there was going to be a trial or not. The challengers said these are pure issues of First Amendment law. They don't involve any development of the facts. We believe strongly that absent a really intense factual record, we would not be able to make the case that we needed to make in order to establish that, in fact, the law was entirely constitutional in various applications. And so we had a very, very long, summer-long trial putting together a record in the case. And when the case went up to the Supreme Court, the court had a lower court opinion that takes up an entire volume of FSUP all by itself. And the record in that case, made all the difference in the world. And so that's what Reed understood that his predecessor did not.
So I have a question for both of the appellate lawyers on the panel. Carter and Seth, lawyers generally advance all legal arguments that may serve their client's interests, the goal being to win with whatever point is successful. But in a test case at the Supreme Court level, the goal is to make sure that the court decides the case on the focal issue rather than a peripheral question. So my question to both of you is, can a lawyer get a victory in a case, but the ruling still be a setback as a test case?
Over to you, Carter.
All right, well, I'll take my first shot at it, and then you can get it right. How's that? I mean, the funny thing about this, it depends really on who you're litigating for. If you're litigating for individuals, I think you at the end of the day, a win's a win in general, and that's your concern. There are a lot of, but if you're representing institutions, and not just the United States, but if you're representing states or even large corporations that have multiple stakes at issue, there are wins and there are wins, and there are some instances where you end up with a win, where you make two arguments, one that's much broader, one that's much narrower, and what the client really wants is the broader argument, and so you may end up getting the win, but they're very disappointed by the fact that institutionally, we're going to face this issue for the next 20 years. There's a bit of a conflict of interest between the lawyer in that situation and the client, because if the court goes off on a narrower ground, that means there probably is going to be litigation in the Supreme Court for the next 10 years. And therefore, it creates more opportunities for work in the Supreme Court for us. But clients typically don't view it that way. Their view of the world is, you take your shot. But it's really hard to avoid making narrower arguments for the reasons Seth gave, which is that we know the justices are incredibly incremental in their approach. And while every now and again, they'll come out with a much broader, they get the 5 votes and they'll say something much more dramatic. For every one of those kinds of cases, there are probably at least 10, probably 100, where the court just decides the case on the very narrowest basis. Because the truth is, they get paid the same whether they work really, really hard on a case or do the easiest necessary in order to dispose of the dispute in front of them. And so it's a tough balance. And as I said, for test cases, especially if you're representing individuals, at least from my perspective, you have to represent the individual's interests, and that may mean winning on a narrower ground, but at least getting them relief under those circumstances.
Yeah, I mean, unsurprisingly, I agree with what Carter said. I want to fight the hypothetical a little bit, Claire, by saying that it's ordinarily in the client's interest and therefore the lawyer's duty to present every legal argument available in order to win the case for the client, particularly when the case goes up on appeal. And Steve's example of all the arguments that Albion Tourget was throwing up to the Supreme Court is a good example of it. Lawyers understand, particularly appellate lawyers, and particularly in the Supreme Court, that you don't win your case by a kitchen sink approach. You win your case by showing an appellate court that you've been disciplined about what legal issues and what legal principles you're laying before the court. And that is an important, viewed by judges as an important responsibility of appellate advocates. Now, once you pick your principle, as Carter says, there's often a muscular argument to be made and a more limited argument that can be made, both of which will achieve a victory for the client in terms of a W in the won-loss column. It's not always a terrible thing if you're thinking about, test cases where you're ultimately trying to establish the law or move the law over time in a particular direction, to have the Supreme Court, take a good look at the broad argument and decide, there's a narrower way that we can approach this problem, and let's move step by step. That is exactly what was done by Thurgood Marshall and his colleagues at the Inc. Fund in the late 40s and early 50s. They were perfectly content to take their very limited wins because they were building a cathedral of law.
Steve uses the phrase ginned up. I love that term, ginned up, about the Plessy case. And some modern court watchers criticize test cases and believe that cases should just move organically through the appellate system without support from outside groups. Is there anything unethical or unseemly about the use of test cases to secure rulings by justices? I'll ask Seth.
Okay.
No. The courts are appropriately muscular in evaluating both personal and subject matter jurisdiction. Article 3 in the federal court's Article 3 jurisdiction, you have to show that there is in fact standing. That is, that somebody has been injured in, the plaintiff has suffered injury in fact that can be redressed by an order of the court, which is a way to weed out pretextual cases. I'm not sure this is an ethical issue, but there's a lively debate that's going on right now between two different groups of organizations that represent people in litigation in the Supreme Court. On the one hand, there are Supreme Court clinics in law schools, and Carter has been a founder and long been affiliated with one of the best of them. Their mission basically is to teach students by finding cases that might be cert-worthy. Any case that might be cert-worthy, whether in terms of the broad scope of where the law ought to move or not move, is not a particular consideration. And there's tension between that instinct and the instinct of issues groups on the left and the right. I mean, I have spent a professional lifetime representing people on death row and in habeas litigation and juveniles in the criminal justice system. And there are, in that regard, we try to be very, very deliberate about when to take our shot and where to put our resources in cases in courts that make law, and sometimes are dismayed by cases that are brought by others that end up presenting the issue in the appellate courts in a quite an unfavorable light. But it's not really a question of ethics. I mean, you know, as I was indicating at the outset, it's only the Solicitor General who both is the lawyer and a decision maker for the client. The Solicitor General represents the United States. And the Solicitor General can say, yeah, you know, the United States lost this case. We should have convicted that defendant. You know, we should have established this proposition or the authority of this agency to do this thing. This is just not the best case to test that proposition. We're going to wait for something else. That's not, as Carter indicated, you know, once you have a client that's not the United States, you can't decide that. You know, maybe the general counsel of a big corporation can say, you know, we lost, but, you know, we've got our eye on what's really important to us. We're not going to take this any higher. If you're representing an individual, it's just like, look, I don't want to be going to prison. I don't want to be executed. I want you to make all the arguments in every court you possibly can that's going to save me from this unjust fate.
Yeah, I'll just add, you know, as somebody who does the clinics and has been doing them for 15 years, actually, the original impetus for all of this came from the Administrative Office of the United States Courts, who asked me probably 20 years ago whether or not it was possible to set up something like the Solicitor General's arrangement for the federal public defenders. And I said, the answer is no, because unfortunately, you can't do what Seth was able to do in his years in that office, which is to say to his clients, you know, you're not going up to the Supreme Court because you're not the best case for us to fight that fight. You know, I can't say, look, you know, I recognize you've got a legal issue that the Supreme Court would be interested in, but I really don't like your facts, and therefore you're going to have to wait. You'll only do 20 years in prison, no worries, you know, but you'll be really happy with the rule of law that's going to come down in the sixth case later. That's going to make you feel really good about your 20 years in prison. I mean, it's just not an option, and so you know, there's that inherent imbalance. But you know, in terms of test cases in general, again, I can't bring them without a client. And while the one thing Steve said that was sort of most jarring was the idea that you could talk somebody into violating the law and therefore exposing him or herself to jail time or maybe only a fine. But anyway, to that, I mean, that's tough. But, you know, there are certainly some individuals perfectly happy to take on that kind of a burden. And if they did and they want to do it in order to present an important legal issue, I certainly wouldn't hesitate to represent them under those circumstances. I'd be reluctant to tell somebody, you know, go violate the law in order to create a good test case for me.
You know, just to interject on that, they did ask for this volunteer, first Day Dunes and then Plessy, with the idea that they were doing a habeas corpus case. And I don't really know how they thought this was going to work, because if the judge who did them the favor of not holding a trial and instead ruling on the constitutionality of the act, had he held the trial and then he had sent Plessy to jail because he needed to be in jail, not just fined, was he going to stay there for months, years, until the Supreme Court actually got around to it? I don't really know what they thought, but they lucked out because Ferguson wanted the case tested, wanted the law tested too. So did the railroad, because economically, what's the point of running separate cars if you don't have to? Now in Georgia, the Georgia Railroad made plain in an ICC case, that is the Interstate Commerce Commission, which was a new federal agency, that it fully intended to run separate cars because that's what they believed was right. They believed in separation, they believed in discrimination, but not in Louisiana. So Carter, I don't know how they thought Plessy was going to survive that, but they made plain in their final report that they never wanted their plaintiffs to be, I mean, their volunteers to be in jail, and they were bailed out. They were met at the court by lawyers who bailed them out that night. in both cases. But that was pre-trial.
So Seth, we'd love to hear you talk about defending against test cases, which you did in the OSG. What can you tell us about the other side?
Well, it's nowhere near as much fun. I've done it both on behalf of the United States in a series of cases that I subsequently wrote about, the federalism cases that were so ascendant in the 1990s in the Supreme Court, where cases were brought by definition not by the United States, but against the United States, or in cases in which the United States, generally speaking, was very much committed to defending the constitutionality of the Gun-Free School Zones Act, the Violence Against Women Act, the application of the patent laws and the trademark and copyright laws against states when states are violating those statutory rights in their commercial capacities. And, we were steadfastly defending the constitutionality of all these acts, and almost without exception during my term, losing them all 5-4. I mean, I approached every single one of those cases with the certitude that we had now found a way to distinguish the prior erroneous decisions and get the Supreme Court off of this addiction. But at some point, I can't remember which case it was, I was arguing in the Supreme Court, and Justice Scalia turned around and he said, General Waxman, I think your message to us is we can either agree with you or we can just move on to our next mistake. And my response was, yes, Justice Scalia, as usual, you've got it exactly right. But the clear preference here is to agree with me and not make yet another mistake. Generally, I mean, I think there's two different things. For the most part, when you're talking about defending against test cases, the role of the Solicitor General, because the Solicitor General has very limited ability actually to control how cases are being litigated by the United States in lower courts. And in any event, many of these test cases are coming up against the interests of the United States in private litigation, and the United States has limited ability to intervene in the lower federal courts in those cases. So it's very often a case of there's a case that's being presented to the Supreme Court as a cert candidate, and trying to advise the Supreme Court about, if you are going to take this issue up, here's the best case to take it up and here's not. And in that regard, the SG really can't put a thumb, I think appropriately, a thumb on the scale of the government's interest. The SG really has to be just a truth teller about whether the question is squarely and cleanly presented in a way that the justices can address it. In lower court litigation, which I've, faced on the defensive as well, it's much more, I think, fighting the battle as the party trying to resist a movement in the law to make a full and fair record. So as I said, in the campaign finance litigation that went up to the Supreme Court in FEC versus McConnell versus FEC, we had a months and months long trial. In the litigation that was brought by an organization called Students for Fair Admissions against Harvard, challenging the constitutionality of race-based university admissions, where Harvard, my client, is on the receiving end of this test litigation. We thought, again, it was terribly, terribly important that we have a trial in this case so that all of the relevant facts behind how the admissions program worked and what the goals and aims of it were would be in evidence before a court. And we had quite a battle about this, with the opponents. We tried that case, and I actually and won, and we actually had the argument in the case in the First Circuit last week. And so, I mean, everybody prefers playing offense rather than defense. But if you're a litigator worth your salt, you should be prepared to do both. And each one has its challenges.
Well, sadly, we're running out of time. There's so much more that we could discuss. I wish we had another hour. I think we're probably the best way to end this is to go back to the 1890s and talk about Plessy's legacy very briefly. Steve, your book implies that the Plessy ruling was inevitable, as it left in place segregation laws that were already on the books. But others have argued that Plessy cemented existing separation and fueled greater racial segregation and attitudes of white supremacy for decades to come after. Which is it?
Well, I've learned a little bit about the law here. I'm going to say both. A good lawyer would say both. Here's why it's both. It was an expected ruling, as I said. On May 18th, 1896, when it was decided, the newspapers of the day didn't give it either front page play for the most part, the white newspapers, or it was sometimes, in some stories, it was in the third paragraph, and there was another case of the day that was in the lead. The black newspapers made a bigger deal out of it. And that was because, as I said, the civil rights course of the court was well established. But as time went on, I'm going to give you a little anecdote to show you why I believe this to be the case. So some of our audience would know who Carter Woodson is. He's the founding editor of the Journal of Negro History, the first such journal of its kind, founded in 1915, a Washingtonian. And in 1921, he did an extensive article about all of the Supreme Court cases since the Civil War. What had the court decided? As you can imagine, it was not a very favorable article from his point of view. You would think in 1921 that if Plessy was the most important case, he would have made a big deal out of it. He devoted 2 out of 53 pages to the Plessy case. He devoted 12 pages to the civil rights cases of 1883, which he saw as being the case where mostly the court's course was set. It isn't until, as Seth mentioned, Thurgood Marshall and the Legal Defense Fund, in the 40s, they realized that from their point of view, it's the Plessy case that is the more important case than the civil rights cases, the civil rights cases were about the Civil Rights Act of 1875, a piece of federal legislation. But it wasn't responsible for the segregation that was taking place. And so they targeted the Plessy case. And Seth told us the history of the Solicitor General looking at the Plessy case and saying the court ought to overturn it. So by the 1940s, the late 40s, Plessy was in people's sights. By 1954, when the court ruled in Brown, and effectively, they don't specifically say they're overturning Plessy, but they effectively are overturning Plessy. They are the ones that use the term separate but equal as a shorthand to describe the Plessy case. And as I said earlier, it kind of pains me when I see my brethren in journalism describe the Plessy case with the shorthand that it established the doctrine of separate but equal. The court did no such thing. There's no doctrine announced in Plessy, and it was endorsing a principle of custom that had been going on since the 1830s in the North, and then migrated, of course, to the South after the Civil War. And so I think it's much better to say that what the court did was to endorse the idea of separate but equal, not that to establish a doctrine. And you might say, well, why does it matter, Steve? You're just parsing words here. But I think it matters because we tend to blame the Supreme Court by using that kind of language for segregation. And we can lay some of the blame at the feet of the justices, but the blame belongs with ourselves. This is our country. It's our Supreme Court. It's our state legislatures. We're all responsible for the legacy of slavery and segregation. It's not the Supreme Court's fault.
Well, on that note, I'm going to say thank you very much to my panelists. What a fascinating discussion we've had, and turn it back to the conference